Todd Blanche's DOJ is slow-walking transparency around the Epstein files, and it is doing it in front of a judge. The judge wants answers about why they aren't complying with orders to unredact and release more of the Epstein files. Today's case, which was brought by journalist Katie Fang, aims to address, in part, foreign language records and the government's withholding of some non-victim email addresses.
The pressure on the Justice Department is now moving directly into the courtroom as questions mount over its handling of the Epstein files. The DOJ is facing scrutiny over allegations that it has been slow to comply with orders requiring more records to be unredacted and released. A case brought by journalist Katie Fang is seeking answers on what is being withheld, including foreign language records and certain email addresses that do not belong to victims. And now, a judge wants the government to explain why those records still haven't been released.
The Department of Justice showed up with documents that they were supposed to provide to the court before today's hearing and yet did not. They handed up a binder to the court to try and document, for example, why it was that they identified certain people as victims or survivors in documents. But one of the things that they have done is continue to defend their withholding of handwritten notes.
And the pressure only intensified when the Justice Department arrived in court without all the documents it had been expected to provide ahead of the hearing. Instead, officials handed the court a binder containing explanations for how certain individuals were identified as victims or survivors in the records. But even as the DOJ tried to justify those decisions, another major issue remained unresolved. The department continued defending its decision to withhold handwritten notes, keeping questions alive about exactly what information is still being kept from public view.
This is a Department of Justice that is still declining to provide to a federal judge copies of the handwritten notes and essentially taking the position, trust us. When we tell you, for example, that these handwritten notes are duplicative, that's the decision that we've made. We have no other information for you. And at one point, the DOJ lawyer is even saying to the judge, I'm not sure what you're asking for.
And that dispute reached an even more remarkable point in the courtroom. The Justice Department was still refusing to provide the federal judge with copies of the handwritten notes, instead asking the court to accept its conclusion that the material was simply duplicative. In other words, the DOJ's position appeared to be, trust us. But that answer clearly wasn't satisfying the judge, especially when the government could not provide additional information to support its decision. At one point, the DOJ lawyer even told the judge, I'm not sure what you're asking for, underscoring just how tense the exchange had become.
As we sit here today in August, on August 13th, 2026, each and every day after December 19th, 2025 has been a violation of the Epstein Files Transparency Act. Now, to compound the problem for Blanche and the DOJ, you have violations of court orders. If I were the judge, it would have been a totally different outcome today. I think that it underscores how the frustration of not only me as a plaintiff litigant in this case, but also the American people.
The frustration over the Epstein files is now being framed as a much bigger issue than a disagreement over documents. The argument is that since December 19th, 2025, each day of alleged non-compliance with the court's orders represents another violation, putting Todd Blanche and the DOJ under increasing pressure. For the plaintiff, the issue goes directly to whether the government is following the court's demands, and that frustration, they argue, extends beyond the courtroom, reflecting a growing demand from the American public for transparency and answers.
The judge spent, of a 2-hour hearing, he spent a good 30 minutes talking about an anecdotal story where he himself had found that 4 DOJ prosecutors had violated an order and he held them in contempt. He held them in civil contempt. He said that they purged that civil contempt by turning over documents they were required to do for that court order. 3 out of those 4 DOJ prosecutors appealed, and the D.C. Circuit Court of Appeals upheld his contempt findings.
And the judge's own history with DOJ compliance made the hearing even more significant. During the roughly 2-hour proceeding, he spent about 30 minutes discussing a previous case in which he found that 4 DOJ prosecutors had violated a court order. He ultimately held them in civil contempt, saying they resolved that contempt by turning over documents they had been required to provide. 3 of those prosecutors appealed, but the D.C. Circuit Court of Appeals upheld the judge's contempt findings, adding important context to the frustration surrounding the current dispute.
The Department of Justice fighting to keep some Epstein files redacted during a hearing inside a Washington, D.C. courtroom Thursday. The case coming after journalist Katie Fang sued then acting Attorney General Todd Blanche for the removal of redactions on specific files that detail FBI interviews with a woman who said she was assaulted as a minor decades ago by President Trump, emails about torture, and documents concealing co-conspirator email addresses.
The battle over the Epstein files is now playing out directly inside a Washington, D.C. courtroom, with the Department of Justice fighting to keep certain records redacted. The case was brought by journalist Katie Fang, who sued acting Attorney General Todd Blanche, seeking the removal of redactions from specific documents. And the records at issue are significant, including FBI interviews with a woman who alleged she was assaulted as a minor decades ago, emails involving claims of torture, and documents that conceal the email addresses of alleged co-conspirators.
The act, passed by Congress last year, requires the federal government to make public, with limited exceptions, records and files related to the late convicted sex offender Jeffrey Epstein and his associates. A public phone line ordered by the judge for the hearing did not work, but according to journalist Adam Klasfeld, who was in the room, Judge Emmett Sullivan said the public has a right to know what the hell is going on in this case. The victims have a right to know.
The courtroom fight over the Epstein files is unfolding under a law passed by Congress that requires the federal government to make records connected to Jeffrey Epstein and his associates public, with only limited exceptions. But even the public's ability to follow the hearing appeared to run into problems when the phone line set up by the judge did not work. And according to a journalist who was inside the courtroom, the judge expressed clear frustration, emphasizing that the public has a right to understand what is happening with these records and why so much remains contested. The pressure is now shifting from political outrage to judicial accountability, and that could make this fight far more consequential for the Justice Department. The central question is no longer simply how many Epstein-related documents have been released. The question is whether the government is actually following the orders requiring it to explain what remains redacted, what has been withheld, and why those decisions are legally justified. And inside the courtroom, the judge appears increasingly unwilling to accept broad assurances without seeing the underlying material for himself. That is what makes the dispute over the handwritten notes so important. The Justice Department's position is that some of these records are duplicative and therefore do not need to be separately produced. But the court has been pressing for more than a conclusion from government lawyers. The judge wants enough information to independently evaluate whether the material really is duplicative and whether withholding it complies with the law. And that creates a fundamental problem for the DOJ. The more it asks the court to simply trust its characterization of the documents, the more the court appears to demand direct evidence. The exchange over the notes captures the tension perfectly. When the DOJ lawyer told the judge, "I'm not sure what you're asking for," it highlighted just how far apart the two sides had become. The government was trying to explain its process. The court was demanding something more specific. And underneath that disagreement was a much larger question about who gets the final say when the executive branch decides that certain information should remain hidden. The answer, at least in this courtroom, is the judge. That does not mean every redaction is going to disappear. The law allows information to remain protected in certain circumstances, particularly when revealing it could expose victims or sensitive personal information. But the existence of legitimate redactions does not automatically justify every redaction. Each category still has to fit within the legal framework governing the records. And that is precisely where the judge's scrutiny becomes significant. The court is being asked to determine whether the government's explanations are sufficient. If they are, the DOJ can continue defending the withheld material. If they are not, the court can demand more information, require additional disclosures, or take further action to enforce its orders. For the Justice Department, that creates a difficult balancing act. On one side is the government's argument that sensitive information must be protected. On the other is the congressional mandate for transparency and the court's authority to enforce it. And sitting directly between those two principles is the public. The public wants to know what happened. Journalists want access to the records. Victims and survivors have legitimate privacy concerns. And the government has a legal obligation to follow the rules established by Congress and the courts. Those interests do not always point in the same direction. That is why the courtroom battle has become so complicated. The records being discussed are not all the same. Some involve FBI interviews, some involve emails, some involve handwritten notes, some contain references to people whose identities remain protected. Others involve allegations that may never have resulted in criminal charges. And that means the court cannot simply say, release everything. It has to determine what can legally be released, what must remain protected, and whether the government has properly applied those rules. That is a much more difficult task. But it is also the reason judicial review exists. The judge can examine the government's reasoning and determine whether it actually holds up. And the judge's previous history with DOJ compliance adds another layer to the confrontation. During the hearing, the judge spent significant time discussing an earlier case involving 4 Justice Department prosecutors who were found to have violated a court order. Those prosecutors were ultimately held in civil contempt, and the contempt was resolved after documents that had been required by the court were turned over. 3 prosecutors appealed, but the D.C. Circuit upheld the contempt findings. That history matters because it demonstrates that the judge is not simply making rhetorical threats. There is precedent for the court taking enforcement action when government lawyers fail to comply with judicial orders. That does not mean the same result is inevitable here. But it does mean the Justice Department has reason to take the court's demands seriously, and that is why the current dispute has become so closely watched. The government is not dealing with a judge who is unfamiliar with the consequences of non-compliance. The court has already demonstrated a willingness to enforce its orders. So, when the judge demands documents or explanations, the DOJ has to respond carefully. Every delay creates another question. Every missing document creates another dispute. Every unexplained redaction creates another opportunity for the plaintiff to challenge the government's position. And every courtroom exchange becomes part of the public record. That is how a document dispute can gradually become a constitutional confrontation. The bigger issue is the relationship between the executive branch and the judiciary. The Justice Department is part of the executive branch. The federal court is an independent branch of government. When the court issues an order, executive officials are expected to comply. If they believe an order is legally wrong, there are established procedures for challenging it. But simply refusing to provide information because the government believes it is unnecessary is a different matter. That is what makes the handwritten note dispute so important. The DOJ says the notes are duplicative. The court wants enough evidence to evaluate that claim. The plaintiff wants the government to comply with the transparency requirements. And now the judge has to decide whether the government's explanation is adequate. That is the central conflict, not whether every document should automatically be released, not whether every allegation in an FBI interview is true, but whether the government has met its legal burden when it chooses not to disclose something. And that distinction matters enormously, because the Epstein files contain allegations. Some may be serious, some may be credible, some may be unverified, some may be contradicted by other evidence. A document containing an allegation is not itself proof that the allegation occurred. That is especially important when names or references appear in investigative records. The public deserves transparency, but transparency without context can create misinformation. That is why the court has to approach the records differently from social media or political commentators. The judge is not supposed to determine guilt based on a name appearing in an email. The judge is supposed to determine whether the government has complied with the law. That is a narrower question, but it could still have enormous consequences, because if the court concludes that the DOJ has improperly withheld information, the government could be forced to release additional records. And once those records become public, journalists and the public can examine them independently. That could answer questions. It could also create new ones. And in a case this politically charged, every new document could generate another wave of attention. That is exactly what makes the administration's position so difficult. The more material it releases, the more scrutiny it faces. But the more material it withholds, the more pressure it receives from the court and transparency advocates. There is no politically comfortable option. The only real protection for the government is to demonstrate that its decisions are legally justified. That means documentation, specific explanations, clear legal reasoning, and, when necessary, evidence that allows the court to independently verify the government's claims. The handwritten notes appear to have exposed a weakness in that process. The court wanted to know why the notes were being withheld. The DOJ wanted to rely on its characterization of the material, the judge wanted more. And when the government could not immediately provide the information the judge was seeking, the courtroom exchange became tense. That moment is important because it illustrates what judicial oversight is supposed to do. A judge is not required to accept an executive agency's conclusion simply because the agency made it. The court can ask, what is the document? Why is it being withheld? Which legal exception applies? How do you know the material is duplicative? What evidence supports that conclusion? And have you actually complied with the court's previous order? Those questions may sound procedural, but in this case, they are politically explosive because the public has been promised transparency. Congress passed a law requiring records to be made public, subject to specific exceptions, and now a federal court is trying to determine whether the government is actually fulfilling that obligation. That makes the case about more than Jeffrey Epstein. It becomes a test of government transparency. It becomes a test of executive accountability. And it becomes a test of whether a federal court can compel the government to follow through on disclosure obligations. The broken public phone line during the hearing only added another strange dimension to the proceedings. The public was supposed to be able to follow what was happening. Instead, access itself became a problem. And the judge reportedly expressed frustration over that issue, emphasizing the importance of public access and understanding. That may sound like a small detail compared with millions of pages of records, but it reflects the larger principle involved. A court proceeding concerning public records is itself a public process. People want to know what the government is doing. They want to know what the court is demanding, and they want to know why certain information remains hidden. When even access to the hearing becomes difficult, it reinforces the perception that the entire process is happening behind layers of secrecy. That perception is exactly what the transparency law was intended to address, and that is why the court's role has become so important. The judge is now positioned between the government and the public. The DOJ says it is following the law. The plaintiff says it is not. The court has to determine who is right, and unlike political arguments, the court can demand evidence. That is the difference. A politician can say the government has released everything required. A lawyer can argue that a particular document is duplicative, but a judge can say, show me. That is essentially what is happening. The court is demanding that the government's explanations be backed up, and if the government cannot provide that support, the judge has tools available to enforce compliance. That is why the mention of civil contempt is not just courtroom drama. Civil contempt is designed to compel compliance with a court order. It is not the same thing as a criminal conviction. And that distinction matters. If government officials were ever held in contempt in this dispute, it would not automatically mean anyone had committed a criminal offense connected to Epstein. It would mean the court believed its order had not been properly followed. That is a very different legal issue. But politically, it could still be devastating, because the administration has made transparency a major part of its response to public demands for the Epstein records. Any finding that the Justice Department failed to comply with disclosure requirements would therefore create an obvious political contradiction. The administration could say it is committed to transparency. The court could potentially say the department is not doing enough to comply, and that conflict would be impossible to ignore. The stakes are therefore growing with every hearing, and the next major question is whether the government can satisfy the judge. If the DOJ provides the missing information and the court accepts its explanation, the immediate confrontation could cool down. If the judge remains dissatisfied, the pressure could increase. That could mean additional document reviews, additional orders, additional explanations, and potentially additional enforcement proceedings. The plaintiff's lawyers clearly want the court to take the strongest possible approach. They argue that continued non-compliance should have consequences. They point to the passage of time. They point to the government's incomplete submissions. And they argue that the public has waited long enough for information that Congress specifically ordered released. The Justice Department, meanwhile, is trying to defend the process. It has argued that enormous volumes of material have already been reviewed and released. It has emphasized privacy protections, and it has argued that some information must remain protected under the law. Those arguments are not inherently unreasonable. The question is whether they justify the specific redactions being challenged, and that is what the judge has to determine. The court's review could therefore become a model for how transparency disputes involving massive government records are handled in the future. If the court demands detailed justification for every disputed category, future administrations may face a higher standard when withholding records. If the court accepts broad government explanations, agencies could have more room to determine what remains hidden. Either outcome could have implications beyond this particular case. That is why lawyers, journalists, lawmakers, and transparency advocates are watching closely, because this is no longer just about what is inside the Epstein files. It is about who controls access to government records. Congress has spoken through legislation. The executive branch is responsible for implementing it, and the judiciary is now being asked to determine whether that implementation is lawful. 3 branches, 1 massive controversy, and millions of pages of records caught in the middle. That is the real story unfolding in Washington. And the pressure on Todd Blanche and the Justice Department is unlikely to disappear simply because another batch of documents is released. The deeper question is whether the government can convince the court that its remaining redactions are justified. If it can, the administration gains a significant legal defense. If it cannot, the court may force additional disclosures. And that possibility is what keeps the pressure alive. Because once a federal judge starts reviewing unredacted records personally, the government can no longer rely entirely on public statements to explain what those records contain. The judge can look, the judge can compare, the judge can question, and the judge can order. That is why this courtroom fight matters. Not because it proves that any particular person committed a crime. Not because every hidden document necessarily contains a bombshell, but because the government is being forced to justify its decisions in front of a court. And that is exactly where transparency becomes accountability. The public may still have many questions. There may still be records that remain protected. There may still be disputes over victims' privacy and sensitive investigative information, but the legal process is now moving forward under direct judicial supervision, and that changes everything. The DOJ is no longer simply explaining its decisions to the public. It is explaining them to a judge who can demand evidence. And if the court decides those explanations are not enough, the consequences could become much more serious. So the headline is not that a judge has suddenly declared Trump guilty. That has not happened. The headline is that the Justice Department is under direct judicial scrutiny over its handling of records that Congress ordered released. The judge has already questioned the government's compliance. The court has demanded explanations. The government has been challenged over missing documents and disputed redactions. And the issue of handwritten notes has become a symbol of the larger fight. Does the government get to decide what the public sees, or does the law and ultimately the court get the final word? That is the question now sitting at the center of this extraordinary courtroom battle. And until the judge is satisfied, the Epstein files controversy is far from over.